Chapter 44, Marshalling of Securities, Analysis. Section 865. In general, the equitable remedy of marshalling securities, with that of marshalling assets, depends upon the principle that a person having two funds to satisfy his demands shall not, by his election, disappoint a party having but one fund. The general rule is, that if one creditor, by virtue of a lien or interest, can resort to two funds, and another to one of them only, as, for example, where a mortgagee holds a prior mortgage on two parcels of land, and a subsequent mortgage is on but one of the parcels is given to another, the former must seek satisfaction out of that fund which the latter cannot touch. The right is purely equitable and cannot be asserted at law, except where it is incidental to an equitable defense permitted in a legal action. It is to be observed that the prior creditor cannot be compelled to give up either of his securities this debt paid. The operation of the principle is not affected by the nature of the property which constitutes the double fund, but applies wherever a paramount creditor holds collateral security, or can resort collaterally to other real or personal estate for the satisfaction of the debt. The rules of marshalling securities are applied under a variety of circumstances, but generally, in this country, between mortgagees and judgment creditors, and between judgment creditors. Section 866. Paramount encumbrancer must not be inconvenienced. Relief will not be given if it will delay or inconvenience the paramount encumbrancer in the collection of his debt, or prejudice him in any manner. For it would be unreasonable that he should suffer because someone else has taken imperfect security. Thus, relief has been denied where the fund to be resorted to has been dubious, or one which might involve the creditor in litigation, and a mere personal remedy has been held insufficient to warrant interference. In some jurisdictions it is held that a creditor who has adequate security within the state cannot be compelled to resort to property elsewhere, while in others the fact that a portion of the security is situated elsewhere is held to be immaterial. It would seem that a creditor should not be compelled to resort to property in a foreign country unless it is made to appear that he will not be prejudiced thereby. It is sometimes said that the creditor seeking the relief must show, and make it clearly appear, that the rights of his co-creditor will neither be injured nor injuriously delayed. Section 867. Rights of third parties must not be prejudiced. Relief will not be given if it will prejudice the rights of third persons. The question frequently arises when there are more than two liens to be adjusted. For instance, a third mortgage may be given, covering property included in the first but not in the second. To compel a marshalling of securities would prejudice the rights of this third party. The right to marshalling being a mere equity and not a lien, it is generally held that it is subject to displacement and defeat by subsequently acquired liens upon the funds. This is more clearly so when the subsequent lien is acquired without actual knowledge of the facts. Section 868. Rule applicable only between creditors of one debtor. In order to obtain the relief, the parties must be creditors of the same debtor, and both funds must belong to one debtor. Accordingly, it is generally held that there can be no marshalling as between the debtor and creditor, nor is the doctrine applicable as between a purchaser of an equity of redemption and a prior mortgagee. The same principle prevents the application of the rule as against a mere surety. Section 869. Homesteads. The doctrine of marshalling will not be applied so as to work an injustice to the debtor. Consequently, it is generally held that it cannot be invoked to compel a creditor to resort to a homestead in the first instance. The object of the exemption is to protect the debtor and his family. If a creditor without a lien were allowed to compel its application upon a prior claim, the right might be practically valueless. Some cases even go so far as to allow the debtor a right to compel the mortgagee to resort first to the other property covered by the mortgage. But while much may be said in favor of the justice of this rule, it would seem in conflict with the general principle that only creditors can compel marshalling of securities. In a few jurisdictions it is held that a creditor may compel marshalling even as against a homestead claim. Section 870. Relief given. The right to have securities marshaled is not a lien, but neither is it a mere incident to the remedy. The right is not generally enforced by an independent action, but it exists and may be asserted whenever an opportunity is afforded. Questions frequently arise when the prior lien holder releases property upon which he alone has a lien. or satisfies his claim in full out of property on which both have liens. Of course, if the remaining property is sufficient to satisfy both liens, no complaint can be made. Where it is not sufficient, and the other property is released without a satisfaction of the debt, it is held that the subsequent lien holder is entitled to a preference in payment, to the extent of the amount which should have been realized upon the property released. Where the claim is satisfied out of the property upon which there is a common lien, the junior creditor has been allowed a substitution, or a decree for subrogation, or an assignment of the rights of the prior lender. In some instances an injunction may issue to protect the second claimant in the assertion of his right,